Good afternoon, everyone. And on behalf of the Woodrow Wilson International Center for Scholars, I'd like to welcome you to the nation's living memorial to its 28th president for the annual American Bar Association On the Docket preview of the new Supreme Court term. My name is Will Pomeranz, and I serve as Deputy Director of the Wilson Center's Kennan Institute, where amongst my other responsibilities and duties, I direct the Woodrow Wilson Center's Rule of Law Initiative. While my primary focus has been on Russia and Ukraine, the Center's ongoing interest in rule of law and governance issues spans the globe. But when we approach these issues, we also often do so from an important reference point, and that is the U.S. system. And the U.S. still remains an important source of comparative perspective as we approach global law issues. Here in the United States, we do take great pride in our system of government, built upon the respect for the rule of law, or as President Eisenhower said during the battle over the integration of Central High School in Little Rock, we are a nation in which laws, not men, are supreme. The iconic and enduring symbol of that commitment remains the U.S. Supreme Court. And when you consider the current court vacancy and the potential for more in the coming years, all this happening in a crucial election year, we might expect that the court will be a topic of particular focus as we move closer to Election Day. With that backdrop, the Wilson Center's Rule of Law Initiative is happy to once again collaborate with the American Bar Association's Division for Public Education to bring you this program, and this year we welcome as a new partner American University's Washington College of Law. So thanks to our partners, and thank you for visiting the Wilson Center today. If this is your first time with us, we hope to see you again. And if you are a regular, as it were, welcome back and thanks for your ongoing support. By visiting wilsoncenter.org, you can find a calendar of upcoming events, all free and open to the public. And now to tell you more about today's panel, I would like to welcome to the podium Harry Johnson, Chair of the ABA's Standing Committee on Public Education.
Good afternoon. Good afternoon. This is like church call and response. Welcome to the ABA Division for Public Education's On the Docket Supreme Court program, hosted in partnership with the Woodrow Wilson International Center for Scholars and American University Washington College of Law. I am Harry Johnson, the chair of the ABA Standing Committee on Public Education. Preview is the flagship publication for the ABA Division for Public Education, and for decades has been the only resource to provide detailed analysis of each case before the Supreme Court prior to oral argument. Each preview issue highlights the main issues before the court in a way that is easy for non-lawyers and lawyers alike to understand. For the past 8 years, we have hosted this annual panel with the Woodrow Wilson Center. This year, we are excited to welcome a new co-host, American University Washington College of Law. Today, we've assembled a great panel to help us better understand the significance of the October 2016 term and give us an inkling of how some of the headline cases for the upcoming term might play out. Now, as just a matter of technical precision, please mute or turn off your cell phones or electronic devices before we begin the program. Thank you. Our moderator will introduce each of our panelists, but I would like to say something about our moderator myself. John Milewski is a veteran broadcast journalist and communications professional with extensive experience as a moderator, interviewer, anchor, reporter, and producer. He is currently the Director of Digital Programming for the Woodrow Wilson International Center for Scholars. John, thank you for your generous support of our programs, and I'll turn it over to you.
Thank you, Harry. Thanks very much, Harry and Will. And welcome, everyone. Before we dive into what is always an interesting topic, the Supreme Court, I want to take a moment to recognize someone who I've had the privilege of working with for many, many years in my work with the American Bar Association. That is the director of the Division for Public Education, Mabel McKinney Browning, who will be retiring at the end of this year. And Mabel has been a giant in the world of civic and law-related education, and it will be a big loss, but she leaves a big footprint behind, too, that we'll all continue to benefit from. So please join me in a round of applause for Mabel, who was in the back of the room. Mabel, it's been a pleasure. Fantastic programs, fantastic leadership, and many good meals sprinkled in to that as well. Okay, so we're going to talk about the Supreme Court. Every term is its own thing and has things to recommend as far as interest that goes beyond just legal watchers. This term might be more interesting based on what's happening around the court, with a presidential election and a vacancy on the court, and all the politics swirling around how that will play out. But still, there are going to be some cases that will have significance, and we're going to be talking about some of those. As always, the American Bar Association has assembled a fantastic panel. I will give you a brief introduction of each of our panelists, but I'll also direct your attention to not only Preview, which Harry talked about, which is a terrific publication, chock full of useful information and concise summaries of court cases. And for those of you joining us online, if you go to the ABA's website, you can get yourself a copy of this as well. But also, for those of you in the room, the program that lists more detailed bios of our panel. But let me give you the brief versions from your left to right. Pratik Shah is co-head of Aiken Gump's Supreme Court and Appellate Practice. He's argued more than a dozen cases before the highest court in the land, and before joining the firm in 2013, he served as an assistant to the Solicitor General of the United States Department of Justice. Brianne Gurad is the Constitutional Accountability Center's chief counsel, and prior to joining CAC, she served in the Supreme Court's appellate practice for the firm of O'Melveny and Myers. She also served as a law clerk for Justice Stephen Breyer on the U.S. Supreme Court. Next up is Richard Wolff. He's been a USA Today reporter and editor for more than 25 years and has covered all three branches of government. He's been covering the Supreme Court since 2012, beginning with the first Affordable Care Act case. And finally, Stephen Wormeal is a professor of practice in constitutional law and associate director of the Summer Institute of Law on Government at American University's Washington College of Law. Please welcome our panel. So the way we're going to do this is we're going to do a presentation on the court in 7 parts. And part 7 will be audience Q&A. I know it sounds like a lot, but some of this will be quick rounds. And what we're going to do in part 1 is take a look back at the year that was, the term that was. And so what I want to begin, and we'll go in order of introduction initially, and then we'll just be a little more loose than that. But I'd like to just get some of your thoughts on the recently concluded term of the Supreme Court. If there are any cases of particular significance you'd like to highlight, or any other things that are happening behind the scenes that you think are noteworthy. There's the obvious 800-pound gorilla of the death of Antonin Scalia, and we'll spend a little more time talking about his legacy in a later segment. But at least for now, if you would think in terms of, was there a breakout case, the kind of case that becomes part of the public discussion beyond legal circles, or any other matters that you think are most noteworthy?
Sure. So thank you for having us here. Happy to start off the discussion. So, of course, as you mentioned, last term was really conducted in the shadow of Justice Scalia's passing. And, of course, when they started off the term, the court was, of course, anticipating a full 9-member court, and it started off to be, a potential blockbuster term. And it still had some very significant decisions that were decided despite the passing of Justice Scalia, were decided by a majority of the court. Of course, the abortion cases out of Texas still had a 5-3 majority opinion. The affirmative action cases, actually Justice Scalia's passing created an odd number in that case because Justice Kagan was recused. So in that case, you actually had a 4-3 decision, whereas otherwise you might have had a divided court. And so there were certainly important decisions and a lot of law made last term, but I think the court contemplated making a lot more law in equally significant cases. And I think that is really what stands out. I mean, the 4, and I'm sure folks will have more to say about them, but the 4 that really stand out to me from last term are really not for what they decided, but for what they did not decide. And that is the U.S. v. Texas case on President Obama's administrative action with respect to folks who, 2 parts, but parents of undocumented parents of U.S. citizens or lawful permanent residents, and essentially the permissibility of President Obama's order to give them work status and to defer removal of those subset of aliens. That case, of course, was not decided 4-4 split. There's a rehearing petition, which I imagine we'll talk about later. On the Friedrichs case, the public unions case, another big case in which 4-4 split, so no decision. And then there were two other decisions that I'd mention that we did get decisions from the court, but they were incredibly narrow decisions that really didn't decide much. One was in the Affordable Care Act contraceptive mandate case, the Zubik case, in which the court did something very unusual, one that I can't remember ever seeing, which is essentially telling the parties, we're going to send this back so you guys can go work it out. When we're going to send it back to lower courts to give you kind of time to reach a settlement, essentially. And the Spokio case on Article 3 or on standing, whether it can be conferred by statute, in which they wrote a very narrow opinion that I think all parties felt that they could glean something from. So I think the takeaway really from last term is what they left undecided rather than what they did decide.
Brianna?
Yeah, I agree with that entirely. I mean, I think, in the wake of Justice Scalia's death, and once it became clear that Republican senators were unwilling to do their jobs and give the president's nominee to fill that vacancy a hearing and a vote, there was a lot of question about whether the court could function with just 8 justices. Some of the justices tried to suggest that it wasn't that big a deal. Justice Ginsburg, always very candid in her comments, noted that 8 is not a good number for a multi-member court. And the decisions that Pratik talked about make clear why. The court was unable to resolve some of the biggest cases before the court last term, including, most notably, I think, the U.S. v. Texas immigration case, where we had, a nationwide injunction blocking this immigration initiative. And this is the key kind of case where you need the Supreme Court to rule, so you don't have a single district court judge making law for the entire nation, and the court was unable to rule because it split evenly. I think one thing that's also particularly interesting about these split decisions is you see no opinions in those cases. When the court issues a 4-4 decision, there aren't one opinion from the one group of 4 justices and one opinion from the other group. The court, under modern practice, is just to issue a single one-sentence order. The judgment of the court below is affirmed by an equally divided vote. And so you get not only no resolution to the case, you get no insight from the justices on what they think about the issues in the case. So no insight in that case to what the justices thought about the standing issue. There was a question about whether Texas and the states challenging the president's initiative had standing to bring the suit. No input into what they think about the executive action questions or their understanding of the immigration laws. And I'll note, in addition to the kind of high-profile cases like U.S. v. Texas and Friedrichs v. California Teachers Association, there were other 4-4 cases as well, including one that left unresolved a circuit split. Some courts in some part of the country had ruled one way, some courts in another part of the country had ruled another way. And that's, again, a chief reason why the court gets involved in cases is to resolve these kinds of circuit splits. And the court couldn't do it because it only had 8 justices. So I think that's going to be a continuing part of the conversation as we look ahead to this next term, both the cases the court has granted and also, as the court considers what new cases to grant to fill out its docket, whether the fact that it only has 8 justices is affecting the cases it decides to hear in the first place.
Well, I agree with everything so far, and I would add one more thing really to that in terms of summing up 2015 beyond the Scalia factor, the 4-4 factor, the minimalist decisions. I would add one more actually to that list, and that was the Evenwell decision, because in the Evenwell case, the question was, and I'll let the lawyers correct me as I probably get this wrong, but the question was, right now we have in all the states, one person, one vote. The question coming from the conservatives was, the challenge coming from the conservatives was, well, how about we just count registered voters, or how about we just count the goal was really to knock out undocumented immigrants. It would have also knocked out children. It would have also knocked out people with felony records and the like. But going in, the standard was states can count all people. And coming out, the standard was states can count all people. So it was like a 12-page decision from Ginsburg that really didn't, it basically said the status quo is fine and left kind of the broader question unanswered. The one broader point I'd make about the term was that for the second year in a row, it was a great term for the liberals. In this case, it had a lot to do with Scalia's death, because you had the abortion case come out the way it did, probably would have anyway. It would have been 5-4 instead of 5-3. And you had the affirmative action case, which Kennedy was able to decide 4-3 rather than it coming out 4-4. You also had the no decision, the 4-4 in Friedrichs. This was going to be the case, the labor case, where the conservatives finally, after two earlier cases in 2011 and 2013, where they knocked away a little bit but didn't do the ultimate thing, this was going to be the time when they finally won the labor case, and with Scalia's death they couldn't. So looking back to the year before with same-sex marriage, with one of the Obamacare cases and some others, this has now been 2 terms in a row where the liberals have much more to be happy about than the conservatives on the court. And obviously if we get a 9th justice from, well, we'll save that conversation for later, but if the polls are to be believed, and maybe Hillary Clinton is a little bit ahead at least right now, the court could be turning liberal for a long time to come. So,
I too agree with everything that's been said so far, I think. I guess the only thing I would add, and it's more one of perspective than saying something entirely different, is what I think has already been described leaves me feeling that the term was very much schizophrenic. On the one hand, the court tried when it could to find common ground, typically by narrowing the issue in a number of cases that have been mentioned, and then deciding those cases by close votes. And then we have the other group of cases where presumably the court did the same thing. They tried to find common ground that would command a majority, didn't succeed, and ended up in a 4-4 tie. So on the one hand, you want to kind of compliment them for working to try to find the common ground. And on the other hand, you sort of want to slap them across the face and say, what about the 4-4 ties? Why couldn't you resolve those? And that's the schizophrenic feeling that I was left with.
The number 9, the magic number, this isn't constitutionally mandated, correct? This was an act of Congress that set the number at 9.
Statute.
So is
Since
there,
1869.
so it's been a long run with the number, but is there any possibility that we could see a change in the number of justices?
I mean, Congress right now, if it were capable of passing anything, could pass a statute that reduced the size of the court to 8. The only requirement in the Constitution, since they have life tenure, is that they can't eliminate an occupied seat, because that would deprive a justice of life
Can't fire
tenure.
anybody.
Yeah.
Yeah.
But with a vacant seat, they could, if they wanted to, reduce the size of the court. I don't.
and the even number isn't unprecedented, because when the court started in, 1789,
Right.
it started with 6.
The Marshall Court was even.
And so you needed a majority of 4. It was interesting, they just had a reenactment up in Philadelphia of a case that was heard in the old City Hall in Philadelphia. You needed 4 justices back then, so what did the court do? They sent 3 justices up to hear this reenactment, which is sort of fitting that they didn't have a quorum.
That's all true, but I'll say I don't think Congress will do that, and I don't think it would be a good idea for Congress to do that. There's a reason why Court of Appeals panels are 3 judges, and why the Supreme Court has been 9 justices for so long. And it's for the exact same reason that Justice Ginsburg said, you need to make sure that you can break ties, so you can resolve important issues of law and ensure there's uniformity of law throughout the country.
We're in the year of never say never.
Right. Yeah. Historically, changes in the court composition, court packing and other things have not fared well. So I think we're sticking with 9 for our
Okay.
lifetimes.
So we'll begin this term with 9, and we'll begin our discussion about this term. And the way we do this is, in collaboration with our panelists, we've identified either a case or a grouping of cases that fall under a banner. And each of our panelists has generously volunteered to lead a discussion, 4 different discussions, on one of those areas that we've identified. And so that's what we're going to do now in the next 40 minutes or so. So up first, Pratik Shah is going to lead us on a discussion of some fair housing cases, 2 that have been consolidated together by the court.
Sure. So these Fair Housing Act cases arise out of suits. This particular case is suits by the city of Miami, but there are other cities, counties, local governmental entities bringing similar suits like this in various parts of the country, which is what got the court's interest. So in this particular set of suits, the city of Miami is suing various mortgage lenders, in particular in these 2 cases, Bank of America and Wells Fargo, under the Fair Housing Act for what they call discriminatory loan practices. Essentially, these are what they call the predatory loans that they say were targeted towards African American and Latino residents and neighborhoods within the city of Miami. And what happened, of course, when the housing crisis hit, these predatory loans, interest rates ballooned, led to a number of foreclosures, of course. And what the city says is, as a result of those foreclosures and targeted at Latino and African American communities, it ended up hurting the city in tangible ways, economic ways. One harm that they point to is the decrease in property tax revenues. Property tax values go down once there's foreclosure, so they're collecting less property taxes. And then they also say they had to spend a lot more in terms of social services, public services, once the properties were foreclosed and the neighborhoods took a hit. Now, the defendants, the banks here that filed for cert, do not dispute for purposes of the Supreme Court petition that the city has at least stated some sort of injury, constitutionally cognizable injury. So to brush up on your constitutional law, Article 3 requires that a plaintiff at least have some minimal level of injury, which you call injury in fact. So that is not in dispute. They say, fine, okay, for purposes of this petition, the city has alleged it suffered this economic impact. But they argue that sort of economic injury that the city is alleging here, decreased property tax revenues from decreased property tax values, which arose from foreclosures, which arose from default on loans, which arose from these original loans. They say, look, that is too attenuated to make the city what they call an aggrieved person within the meaning of the Fair Housing Act. So what the Fair Housing Act says is, we're going to give you a private right of action. You can sue if you are an aggrieved person. That's the term that the statute uses, aggrieved person. So the banks essentially say, look, even if they have this Article 3 injury, in fact, they're not an aggrieved person. Now, the district court agreed with the banks, dismissed the suit, said this is not the type of injury that's proximate enough, close enough, direct enough to make them an aggrieved person, dismissed the suits. The 11th Circuit, the Court of Appeals that heard this case, reversed and permitted the court to proceed. And what the 11th Circuit did, it relied on some older Supreme Court cases, Fair Housing Act cases, that said essentially that the scope of aggrieved person within the Fair Housing Act is coextensive with Article 3. That is, it's coextensive with the injury in fact requirement. So it's a broad conception of standing to sue. The banks filed cert petitions, and that's their lead question presented, that is in fact a Fair Housing Act's requirement of agreed person as broad as Article 3, or is it in fact narrower? And if so, if it's narrower, then is the city actually an aggrieved person? They also add a question about proximate cause, has a lot of the same arguments, but doctrinally, instead of doing in standing, they're trying to do it under the causation requirement. Although when you read the brief, we only have the bank's brief so far. It is quite focused on that first question. Now the banks, what they argue is, look, Congress, when it passes statutes, it typically doesn't open up the statute to essentially every person who might be able to state some kind of injury. Rather, what the term that they use, and this comes from Supreme Court precedent, and their best case is a 2011 case called Thompson. They said you must be in the zone of interests of the statute. So for in Thompson, this 2011 Supreme Court case, that involved Title VII, another civil rights statute regarding employment discrimination. The court said aggrieved person within the meaning of Title VII means someone who falls within the zone of interest that was intended to be protected under Title VII. And so the banks say that's what you have to apply here. You look at the zone of interest protected by the Fair Housing Act. It did not intend to protect the city, which itself has not suffered any discrimination. Now the question, of course, is whether the Fair Housing Act then is different than Title VII or these other statutes, so as to allow a plaintiff like the city who has Article 3 standing, despite the lack of any discrimination injury itself, to bring suit. Now, we don't have the brief yet from the plaintiffs, but it'll be interesting to see sort of what tack they take. They can, of course, stand on the pre-Thompson Supreme Court cases that actually dealt with this particular statute, the Fair Housing Act, that said, in fact, that aggrieved person is coextensive with Article 3. It appears, at least I think the better argument is probably that is dictum, and so the Supreme Court, of course, even if it weren't dictum, the Supreme Court has the ability to revisit it, and in light of Thompson, a 2011 case, it may pose a problem for plaintiffs to sort of distinguish the context in Title VII from the context in the Fair Housing Act. So I suspect that plaintiffs will make that argument, but they'll also make another argument that says, look, even if it is the zone of interest test, the city of Miami could well fall within that zone of interest, right? That the Fair Housing Act interests are broader than what the banks say. It's not just about protecting the folks who get stuck with the bad loans or the folks who suffer direct discrimination in housing, but it can also encompass a city here which is trying to maintain its neighborhoods, maintain vibrant neighborhoods across ethnicities and the like. So we'll see what tack the plaintiffs take. But I suspect that they realize that in light of Thompson and the fact that they have an 8-member court here, that perhaps they can get a decision around a narrower decision that would preclude a loss, an outright dismissal, and allow it either to go back in the lower courts or to allow their suit to go forward under this zone of interest test. Standing has become a big issue. It's always been a big issue. There was the Spokeo case that we mentioned last term in the Article 3 context. Here it's a case of statutory standing. Aggrieved person is a term that appears in all sorts of statutes, both civil rights statutes as well as others. So I think there's going to be significant attention paid to how the Supreme Court interprets that language, how they reconcile some of their older cases in the civil rights context, and how they navigate an 8-member court in an area which typically has been not conducive to unanimous opinions, although the Thompson opinion in the Title VII case from 5 years back was actually a unanimous decision. So I think there's a lot to watch.
Pratik, could you give us whether a hypothetical or a real-world example of beyond the legal standards involved, just in what's at stake here for either individuals or a city? What are the things that are at risk depending on how this ruling plays out?
Sure. So I mean, this in some ways, this particular type of suit, is somewhat sui generis in that it comes from the housing crisis. But that's a big deal, right? I mean, cities are struggling to deal with the aftermath of budgets in terms of strict budgets, huge outlays in terms of public services, and then huge decreases in property tax revenue. So big deal for cities that are struggling to figure out some solution to the problems that they felt, look, we're not responsible for this, and so there should be a mechanism to recover that. So I think on the ground, practically, huge consequences for cities and local governments as they struggle to deal with the fallout from the housing crisis.
So either comments or questions for Pratik from the rest of our panel?
Just, I assume there's no way to attach a dollar amount to the downstream impact if the cities are allowed to go ahead with the suits, right?
There was some discussion in the bank's briefs, I think particularly in the cert petition, that we're talking hundreds of millions of dollars. They didn't get a damages figure, but the cities, the bank ran a back of the envelope calculation based upon using some subset of loans, and they're saying, look, this could be hundreds of millions of dollars. So, and this is of course just one of these suits, so potentially big money.
How much do you think the court's going to focus on the case law that you were talking about as compared to, the history of the Fair Housing Act in particular and what Congress was intending to do with that legislation?
Yeah, well, I think the Thompson case is going to be very interesting to see how they deal with that because, you have another civil rights statute there, Title VII. You have the exact same language in that, and they directly interpreted that language there. It was part of the holding in that case that the zone of interest is the right test for that. So my guess, and that was a unanimous decision.
How explicitly defined is the zone of interest?
Not very. that gives them a lot of flexibility. So I think they will tend to go in the direction of Thompson, but where I think where the history of the Fair Housing Act may come into play is in articulating what are the outer boundaries of that zone of interest. So it may give them some flexibility to leave that, and especially with an 8-member court, they may use that as a sense to say, hey, look, we're in the zone of interest, and maybe we need some further development of what that means.
The inclusive communities case from a year plus ago, 2 terms ago, that has no bearing on this case whatsoever, right? The whole issue of disparate impact.
Yeah, no, it won't. There's no legal tie.
Right.
To this case. That's right.
Thank you for taking.
That's right.
We are, I think now this is, according to my notes, it's 2 minutes for Secretary Clinton and 2 minutes for Donald Trump to respond, and then next up is Brian.
Wrong.
Brian Garrod is next, and Brian's going to be talking about a couple of cases that fall under the heading of criminal justice, the criminal justice system and race.
Yeah, so there are a couple of really important criminal justice cases on the court's docket this term, and I think they're particularly significant because they do tee up this issue of the role that race plays in our criminal justice system. There's obviously, an ongoing broader national conversation about that topic, and it's one that came up at the court briefly last term. There was a Fourth Amendment case in which Justice Sotomayor was in dissent and wrote a very powerful dissent, many refer to it as her Black Lives Matter dissent, in which she spoke very frankly about the role that race continues to play in our criminal justice system. Well, this term in these 2 cases that the court's going to hear very early on, all the justices are going to have to confront head-on this question of, do we allow race to play a role in the administration of our criminal justice system? The first case I'll talk about is Peña-Rodriguez v. Colorado. This is a case about racial prejudice, racial bias in jury deliberations. The facts of the case are fairly straightforward. Mr. Peña-Rodriguez was charged with 4 counts of sexual assault and harassment. Someone harassed and groped 2 teenage sisters in a bathroom. Mr. Peña-Rodriguez always consistently denied that he was the assailant, and so went to trial. At the trial, I should say, there was no physical evidence, no forensic evidence tying him to the women or to the crime scene. So it was really a question of conflicting testimony, the word of Peña-Rodriguez and his alibi witness against those of the 2 victims. The jury deliberated at length. Initially, it actually couldn't return a verdict and told the judge that, and the judge said, no, keep trying. Let's get a verdict here. And so ultimately, they convicted him on 3 misdemeanor counts, didn't return a verdict on the felony count he was charged with. So after the jury was dismissed, 2 jurors came forward and said that another juror made a number of racially prejudiced, racially biased statements during the course of jury deliberations. There were a number of statements that were allegedly made to give you an indication. He allegedly said that he knew the defendant did it because he's Mexican, and Mexican men take whatever they want. He allegedly said that Mexican men had a bravado that caused them to believe they could do whatever they wanted with women. And he also said that he didn't credit Peña-Rodriguez's alibi witness, who was also Hispanic, because he was, quote, an illegal. And it's worth noting that the witness had actually testified at trial that he was a legal resident. So it's difficult to imagine, I think, more explicit, direct evidence of racial bias infecting jury deliberations than we have in this case. But the trial court said that those allegations couldn't form the basis for a new trial because of a rule that exists in the Colorado evidentiary rules called a no impeachment rule. That basically says you can't look behind what happens in the jury room. You just can't go inside of what happens during jury deliberations. This rule, I should say, is not unique to Colorado. It is in the federal rules of evidence. It's part of a number of states' rules of evidence. Peña-Rodriguez appealed. The Colorado Court of Appeals affirmed the trial court's decision in a divided decision. And the Colorado Supreme Court, also in a divided 4-3 decision, upheld the lower court's decision. So the question before the court now is whether you can apply no impeachment rules like Colorado's in a case like this one, where you have allegations of racial bias, racial prejudice infecting the jury deliberations. We at CAC, at the Constitutional Accountability Center, filed an amicus brief in the case, arguing that you can't, that it bumps up against both the 6th Amendment right to an impartial jury and also the 14th Amendment guarantee of equal protection under the law. That those amendments together represent our national, constitutional, and historical commitment to race-blind decision-making in the jury context. And so allowing an individual to be convicted when there are allegations of racial bias runs afoul of those protections. Colorado offers, in response to this, a number of policy rationales, justifications for no impeachment rules. I think most prominently the idea that jury deliberations should be secret. And there's something to that, right? You want jurors to be able to talk candidly and frankly when they're trying to decide how to decide a case. But what's important to recognize about this case is that Pena-Rodriguez doesn't argue that you can't apply no impeachment rules at all. What he says is you can apply the rule, but you should have a narrow exception for cases like this that present racial bias, that present allegations of racial bias. And it's worth noting that a number of states that have rules like this one do actually admit an exception for cases like this, and that even the Colorado rule has a few other exceptions. So there's reason to think you could have an exception, it'd be easy to administer it. So the court will be hearing oral argument in this case the second week of the term on October 11th. The other case that tees up this issue of race in the criminal justice system is Buck v. Davis. This is a capital case out of Texas, a death penalty case out of Texas. And the facts in this case are, I think, truly stunning. Dwayne Buck was convicted of murder. He then had a sentencing hearing to determine whether he would receive life in prison or the death penalty. Under Texas law, no one can be sentenced to death unless the jury concludes that they're likely to be dangerous in the future. And that was the key question at Mr. Buck's sentencing hearing. At that hearing, defense counsel, so Mr. Buck's own attorney, called a purported expert witness who said that he was likely to be dangerous in the future because he is black. So I think it's worth pausing on that. His own counsel, at a sentencing hearing where the question was, is he likely to be dangerous in the future, said yes, he's more likely to be dangerous in the future because he is black. So, Mr. Buck was then sentenced to death. The decision was affirmed on appeal. The procedural history of this case is actually fairly complicated. He didn't initially raise this testimony or his counsel's decision to elicit it when he sought post-conviction relief in state court. He then went to federal court and raised an ineffective assistance of counsel claim. The Sixth Amendment, of course, promises not only counsel, but that they will be effective. The federal court said, no, it's too late to bring these claims. They're procedurally defaulted. Fast forward, there's intervening Supreme Court case law that says that federal courts can actually consider this type of claim, even if it wasn't raised in state court. And so he goes back to federal court and says, reopen my case. And there's a federal rule of civil procedure, Rule 60B, that says you can reopen a final judgment under certain specified circumstances, including when there are extraordinary circumstances. And so he says it's difficult to imagine a case that is more extraordinary than mine. You should reopen it. The district court says no. It acknowledges that he didn't receive effective assistance of counsel, but says, well, the effect of that testimony was de minimis. It then denies him a certificate of appealability, which is the kind of document that he needs to be able to appeal that decision to the Fifth Circuit. And the Fifth Circuit, too, denies him a certificate of appealability, saying that reasonable jurists couldn't disagree that there's nothing extraordinary about his case that would warrant reopening it under Rule 60B. So that's the very technical question of the case, is whether he was entitled to appeal that decision, whether he was entitled to a certificate of appealability. But of course, it too really tees up this question of what role are we going to allow race to play in our criminal justice system? Are we going to allow someone to be sentenced to death because he is black? And so we also filed an amicus brief in this case detailing not only the constitutional commitment to race-blind administration of justice that we talked about in our Pena-Rodriguez brief, but also talking about long-standing, persistent racial stereotypes that present African-American men as likely to be violent. And we talk about how persistent that stereotype is, and all of the evidence, all of the studies that suggest that that stereotype has a demonstrable effect on people's perceptions and their judgments, such that once this testimony was elicited at a sentencing hearing, particularly by an expert witness, it's impossible to think that it wouldn't have had an effect on the jurors who were deciding whether to sentence him to death. So the court will be hearing this case on October 5th, the second day of the term. And so together, I think these cases are really going to give the court a real opportunity to make good on a commitment it's articulated in the past, which is that race and race discrimination should play no role in our criminal justice system.
Brianne, you had the vantage point of working for Justice Breyer.
Yeah.
In cases like this, when the larger context, the passion, the anger, the around race and justice in the United States currently, how either sensitive to that context are the justices or immune to those larger contexts feelings and issues are the justices?
You know, the justices live in the same world that everyone else does. So, I mean, they're certainly aware of the conversation that is going on out there. I think Justice Sotomayor, in the dissent I mentioned earlier, you know, brought those concerns even more to the fore. I mean, they're certainly going to decide the case based on the law. And, you know, in, Mr. Buck's case, for example, they're going to consider the standard, of whether this is extraordinary circumstances. But I think, they are certainly aware of the larger conversation. And I think, one reason why there are so many passions, why there is this national conversation, is because there's a sense that, everyone has that race shouldn't be playing a role in the way that, people are judged at trial. They shouldn't affect the way that they're sentenced. I mean, this is, goes back to the Constitution itself. This is why, we have a Sixth Amendment that promises an impartial jury, why we have the 14th Amendment. People are supposed to be judged based on the evidence presented at trial and what they did, and not based on the color of their skin. And so I think, the same things that are affecting our national conversation, will affect the justices as well, but they'll of course decide the case, within the parameters of the law.
Thoughts from your fellow panelists, either questions or comments for Brian?
We had a moot court on Peña Rodriguez at a session in Williamsburg, William and Mary, last week. It was irrelevant really how it came out, because those of us who were judges were just trying to come up with a representative sampling of how the court might rule. But one of the things that was brought up afterwards for those that went against the defendant was, where's the limiting principle in this? What happens if the next case is based on gender, or the next case is based on religion? There's any number of reasons why you might peel back the veneer of the jury room and say, well, race isn't the only thing that we ought to be considering. So could that be a factor working against him?
Well, I think one of the things that's nice for the court, right, is they don't have to decide those cases now. All they have to decide is this case. And, interestingly, there was a case from, a few years ago where the court, refused to find an exception to the no impeachment rule. But Justice Sotomayor, writing for the court, said, there could be cases where we will, and I think mentioned race explicitly as one of them. And I think given, the protections in the 6th and 14th Amendment, given the special importance the court has long attached to making sure that race doesn't factor into our criminal justice system, I think the court can say here, we can't apply the no impeachment rule in this context, and it can say for another day, those other questions.
In some ways, the 8-member court, might have an interesting role here, where, they realize that any decision they issue has to be narrow. And these are the types of cases where you have kind of extraordinary circumstance exceptions, where you want narrower opinions if you're a justice, for the very reason that you identified. It's hard to articulate limiting principles. And so in one sense, the 8-member court may actually make it, in some sense, more conducive to write a decision in these sort of cases than it otherwise would be when you're trying to sort of stake out ground, where if you can find a majority to coalesce around a very narrow principle that, death is different, and when you have explicit statements about race affecting that decision, that's an extraordinary circumstance. And in the jury context, you have that and there were other facts that I recall. I think in the death case, didn't Texas say that it would waive its procedural bar for this subset of cases, and then took back that representation? So I think there are factors in each of these cases. While it may not be helpful, the Supreme Court usually likes to be helpful to lower courts for future cases. They view that as a significant part of their job. There's a subset of cases where they sacrifice that goal of clarity for future decisions and for lower courts, and just try to decide the case in front of them. And having an 8-member court with these extraordinary circumstances might lend itself to that sort of decision here.
Yeah, and I'll just to elaborate on that, there were, I think, 5 other cases in which this sort of testimony was presented. Texas conceded that this was unconstitutional and said it wouldn't object when individuals who were sentenced with that testimony presented tried to reopen their cases, and it made good on that in 5 cases, but not Mr. Buck's, which is pretty stunning, and is just another fact that I think suggests that there are extraordinary circumstances here. I also think I agree with what Pratik said about how the court could be driven to more narrow decisions, and there's certainly opportunities here to write more narrow decisions. But I also don't think these are necessarily cases that would be 5-4 even on a 9-justice court. I mean, I think, we've seen Justice Kennedy recently, being, I think, very sensitive to the role that race continues to play in our society, in the affirmative action case last term and the fair housing case that from a couple terms ago that Rich mentioned. Also the central proposition here that race shouldn't play a role in our criminal justice system is one that, the Chief Justice should support, given his comments about the importance of, moving toward a race-blind society. So I don't know that we'll necessarily see close decisions in these cases.
One of the things that has come out during these discussions over the years is the fact that most cases don't break down on such clear partisan lines. They're just the ones that we tend to think about more or know more about.
That's right.
The boring unanimous decisions are the ones we don't talk about. Speaking of issues that have a significant contemporary context, voting rights cases, Richard Wolff is going to be talking to us about some of those.
Well, I was going to say, speaking of race, because the two cases that are coming up probably in December, they haven't been scheduled yet. I guess it's if the court thinks perhaps that these could be 4-4 cases, or that one of them could, maybe they're not in December, maybe they keep getting pushed back, but they've been granted. They were both granted in June. A couple of words on redistricting first. These are cases from Virginia and North Carolina. There are also, just quickly on the subject of voting rights, I'll talk about that at the very end. There are not cases coming up on a merits basis, but there have been a slew of cases, as you probably know, coming up in terms of stay petitions, which happens every 2 years before elections. The court has ruled on some in North Carolina, in Michigan, in Ohio. A couple of others are kicking around in the lower courts. But that's sort of a separate issue. Eventually, voting rights could get to the court, probably not in this term on a merits basis, but what I'll be talking about here is more the redistricting cases. And this is an area that the court has to get involved in because these are mandatory appellate review cases. They come up from 3-judge district court panels, and the court has a choice, but they tend to take these cases when they feel that they need to weigh in. And so these two are, and also I should say, this is a murky area for the court. It's a balancing act between the neutral criteria that the court has to consider in terms of redistricting, and that the state legislatures have to consider population, municipal lines, communities of interest. They have to balance those against the Voting Rights Act and what Section 2 and previously Section 5 had to say about what states had to do. And then there's the overarching issue of politics. And in these cases, race and politics are pretty much identical, and that's what makes all of these cases interesting, because legislatures are getting involved with race, but they're doing it for political purposes, because if they move African American voters in this direction or that, and therefore are moving white voters in this direction or that, they're doing it 99 times out of 100 because it affects how the Democrats do, how the Republicans do. The North Carolina case, interestingly, involves 2 congressional districts in North Carolina, Districts 1 and 12, that were part of the original Shaw v. Reno case, or were the original Shaw v. Reno case in 1993, and those districts have been before the court 4 times already. So this shows that this is kind of a murky area, and an area that the court can't seem to shed. It's partly its own fault, because it's never come up with a really clear standard on these racial cases, and it has no standard whatsoever on partisan gerrymandering, and maybe we'll be getting to a partisan gerrymandering case in the future, but perhaps relatively soon, because there are some of those kicking around in the lower courts also, from North Carolina, from Wisconsin, from Maryland, a very good one in Maryland, but that's for the future as well. So I mentioned Shaw v. Reno, Districts 1 and 12 in North Carolina. District 12, a lot of you probably know, is the I-85 district. It's the epitome of a district that doesn't look like it deserves to exist, because it just basically carves its way down through central North Carolina. The court said in Shaw v. Reno, if race predominates, then you go to strict scrutiny. They remanded that case. It went back and forth through the 90s and into the first part of the 21st century. And ultimately the court said, pretty much, I think I have this right, that in District 1, the Voting Rights Act kicks in, and it was narrowly tailored enough to survive under the Voting Rights Act. And with District 12, they basically said, Well, it's partisan, and that's okay. The legislature is just being partisan. Now what you have over the years is, it used to be Republicans that were challenging Democratic districts when the Democrats throughout the South controlled most of these state legislatures. Now it's the Democrats challenging the Republican districts, saying that what the Republicans have done over the last couple of decades is they've packed African Americans in larger percentages than necessary into some of these districts, whether they're state legislative districts or whether they're congressional districts. And the purpose of them doing that is they're acknowledging that that district is going to go to a Democrat. The purpose of the Voting Rights Act is to say that it ought to go to somebody who the African American or the minority community there is supportive of. Doesn't have to be an African American. But what's happened is that it makes the other districts nearby whiter and more Republican. And that's really what's going on in most of these cases. So as I said, there's no firm standard that the court has come upon for race. There's none at all for politics. More and more of these cases are coming. And I guess that you can judge whether that's a bad thing or a good thing. In this year, with such a depleted docket, I guess it's a good thing that we at least have something to report on. The other factor that I'll mention before I briefly talk about the two cases is the court in 2013 issued its landmark decision in Shelby County v. Holder, and that was a Roberts decision 5-4 that struck down, technically didn't strike down Section 5, but it made Section 5, but it made it irrelevant because it struck down the way that states and parts of states were drawn into that section. It basically said that goes back 40, 50 years. You can't do that anymore. Congress isn't probably going to be able to come up with a solution to that. So what's happening as a result is you're getting more voting rights cases coming up, mostly from the South. It's possible we'll get more redistricting cases after the 2020 census. And you have a cottage industry of civil rights and voting rights groups and groups like Brienne's who are challenging all of these Republican-drawn districts more and more, and the things that Republican legislatures are doing in terms of voting rights. 2015, the court handled an Alabama case that is the most recent one prior to these two in Virginia and North Carolina. The court said 5-4 in a Breyer decision. I think it was a Breyer decision that Alabama went too far in basically packing African Americans into certain state legislative districts. Oddly, or I guess I should say not oddly, but what you might expect, there were two sets of plaintiffs. There were black legislators and there were Democratic legislators, two different groups of legislators overlapping, in essence, challenging those districts. And that kind of illustrates how race and politics are becoming the same thing in these cases. So the two new cases come from Virginia and North Carolina, probably going to be heard in December. They're sort of mirror images. The Virginia case comes in a situation where the state was upheld in the way it drew the 12 state house districts that are being challenged. In North Carolina, the state lost in terms of the way, in the lower court, in terms of the way it drew two congressional districts, numbers 1 and 12. Both were granted in June. Both trial courts, these district court panels split 2-1 in the two cases. And both states were under Section 5. This goes back to the 2010 census when these lines were drawn, although Section 5 basically no longer exists. So the Virginia case, 12 House districts, they were drawn so that they would include, by the Republican legislature, so that they would include at least 55% African American population. Prior to that, some had that number, but some had been as low as 46%. In October, the district court said race was not the predominant factor that the legislature used in 11 of those 12 districts, that they had looked at other factors as well, and that you have to be able to show that the other factors played no role whatsoever, in essence, is what the court said. So they allowed the districts, and in the 12th, they allowed that one also because they basically said the percentage of African Americans that the legislature put in was okay under the Voting Rights Act because it was narrowly tailored. The Solicitor General's office, interestingly, is okay with that 12th one, but they want the 11 reversed. So they're siding with the challengers. Mark Elias is representing the challengers in this case. And then there's the North Carolina one, 2 congressional districts, 1 and 12, drawn after the 1990 census. They already elected blacks, and they were drawn in this most recent iteration at 50% or more, where the 2 African-American members of Congress had been getting elected easily in the 40s. The district court ruled that race was predominant in those 2 cases. You didn't need the 50% for Voting Rights Act compliance, they said. And I should note what happened as a result of the way the legislature drew these districts is that 3 other districts moved from the Democratic side to the Republican side in the next election. So clearly what the legislature was doing in this case was using race, but it was using race to get at politics. Well, I guess the question is, were they using race? Paul Clement is representing the North Carolina plaintiffs in this case, and he basically is arguing that District 1 was required to be at the level that the legislature drew it at for the Voting Rights Act. And basically the District 12 was done for partisan reasons. So again, we haven't gotten to the point yet where we have any case law, or at least any Supreme Court precedent on partisan gerrymandering. These could be 4-4. It's unlikely that they'll both be 4-4 because they would come out differently. You'd be allowing them in one case and disallowing them in the other. Kennedy is probably the key. And as I mentioned earlier, partisan gerrymandering cases in Maryland, in Wisconsin, in North Carolina are lurking behind these. It would probably be a bigger case and a more important case if the Supreme Court eventually weighed in on the use of politics in these districts and set up a standard of what was allowed and what wasn't allowed. Very briefly, let me just mention voting rights. Every 2 years, the court gets involved in these petitions. Basically, they've ruled based on a precedent called the Purcell precedent. And in this case, what happens is they don't necessarily line up, the court doesn't necessarily line up with the voting rights challengers or with the state legislatures. They are basically trying to leave in place whatever voters are most used to. These are sort of emergency stay petitions. They're not merits decisions. They let the challengers win in the North Carolina case most recently. That's a very broad voting rights statute the legislature enacted. In Michigan, they let the challengers win because these are the way the lower courts had come out. That was on the issue of party line voting in Michigan. In Ohio, they went with the state and allowed the state to knock out what's called Golden Week in Ohio, when people could register and vote simultaneously. There are cases from Kansas, Georgia, Alabama, Texas, Arizona, Virginia, others kicking around. These are all cases that I don't know that any more are going to come to the Supreme Court. They're in various lower courts. They affect who's going to be able to vote, who's not going to be able to vote in this election. That's why they're important. But in terms of a merits case getting to the court, that's probably another term away. The Texas and the North Carolina cases are probably the best bet at this point for one of them getting to the court. And we'll talk about this later, but if it's a Clinton victory in November and we get a liberal judge, a liberal justice, that area is probably one of those most ripe for challenge.
Given all this activity that you described, the earlier Pratik and Brianne were talking about sort of the difference between when the court is interested in making a very narrow ruling and not setting any broad precedent versus where they might look for a case where they can assert a very clear precedent to make the job of lower courts easier. In this area, is this a classic hot potato that they'd rather keep it narrow?
That's a good question. I think that they're going to look at the set of facts in each case. I mean, the Alabama case was a fairly significant case, but I guess you'd call it narrow because it doesn't stop the next case from coming that looks awfully similar. So even though the court in 2015 said, and it was a 5-4 decision, I think, and they said, no, Alabama went too far in what they were doing in terms of the percentages of African Americans that they were putting in districts. Boom, you've got North Carolina and Virginia cases that come right back. And in one of those, the district court doesn't seem to have been influenced by the Alabama decision. So I don't know that it's a question of narrow or broad as much as it's a fact-based question on, you get down into the nitty-gritty of what was the person who was hired by the legislature to draw the maps told he had to do, et cetera, and so forth.
Any quick comments or questions?
And just kind of following up on that, I'm curious if you agree. I mean, it seems like this is also a somewhat unique area because, as you said, these are cases of mandatory jurisdiction. So the court has to take them. It has to weigh in. When the court denies cert, it's making no law whatsoever. But when it has one of these cases, it has to either summarily affirm, which means affirm the judgment of the court below, even without briefing, argument, or summarily reverse, or it has to go through the whole process of hearing oral argument and briefing. And so it seems like it's been pretty reticent recently not to kind of give full hearings to these cases that come up this way.
Right. And I guess, again, this is why this whole area of case law at the Supreme Court level is murky, because each case, and these two might be examples of this this year, come out based on the particular set of facts. And the court is not trying to say, we are coming up with a brand new large precedent on the use of race in drawing districts. It usually is more about you can do this much here and this much there, but not that much there.
Yeah, I agree with that. I think the one difference, though, between those your cases and Breon's cases are, in Breon's case, I think you can have a narrow principle that a majority of them, or maybe all of them, can agree on, given the facts of the case. We'll see. Much less likely, I think, in the vote, even though fact specific, they just tend to be much more divisive, because there you're talking about a use of race that's hotly contested. There, everyone can agree with the general principle that you shouldn't be, using race in a way that, puts someone at a disadvantage in the criminal justice system. However, there are stark disagreements about whether you should be using race in determining, and to what extent you should be using race in determining voting districts. And I think that's why even when you get fact-specific decisions, they tend to be 5-4.
Right.
In that area as opposed to other areas.
Can't be 5-4 this time.
Can't be 5-4.
At least for the time being. Well, certainly an evergreen area in American jurisprudence is the church and state issues. And Steve Romeo is going to talk to us about one of those.
So I'm going to talk about Trinity Lutheran Church of Columbia versus Pauley, which is a case that comes to us literally from the playgrounds of Columbia, Missouri. The state of Missouri adopted a plan in which they would subsidize nonprofit organizations in the state using used tires, basically chopping up the rubber of used tires to make playground surfaces. It had the obvious benefit of having fewer used tires in waste dumps and creating safe playground surfaces. So nonprofits that operated child care centers, daycare centers, schools could buy these used tires, resurface their playgrounds, and apply to the state for funds to pay for it. Sounds simple enough, makes a certain amount of sense. The problem arose when Trinity Lutheran Church in Columbia decided that they wanted to apply for one of these grants to resurface their playground, and the state turned them down because they were a religious organization. The state of Missouri has in its constitution a provision that says that no public funds may go to any church organization. It's a version of what's called a Blaine Amendment. Blaine was the Speaker of the House of Representatives in the 1870s, James Blaine from Maine, and he proposed an amendment to the U.S. Constitution to prohibit the use of public funds to religious organizations, including religious schools. It didn't pass. It was not approved. It's not, in case you haven't noticed, it's not part of the Constitution. You can check. But many states passed versions of that amendment in their state constitutions in the late 1800s, and many of those provisions still exist, including Missouri. So Missouri says we're not going to spend public funds to a religious organization. Trinity Lutheran Church is a religious organization. Doesn't matter to the state of Missouri that what they want is a playground, which is not part of the religious mission of the organization. So the question here is an interplay among several parts of the Constitution. The The church went to federal district court to challenge Missouri's decision, lost in federal district court, appealed to the Eighth Circuit Court of Appeals. The Eighth Circuit ruled against the church as well in a 2-1 decision. The interplay is it's a three-way interplay. It's among the Establishment Clause and Free Exercise Clause, the religion clauses of the First Amendment, and then the Equal Protection Clause. There was actually a free speech claim in one of the early stages of the case. It went away, which I think is probably the right outcome. The Court of Appeals, in ruling against the church, said, and I'm going to say this twice because you got to bear with me to catch the interplay. The Court of Appeals said that under the Establishment Clause, the state of Missouri would be allowed to include the church in a grant program, in a public service or state services grant program. If it's a neutral program that's being made available to anybody who has a playground, under the Establishment Clause, Missouri would not be violating the Establishment Clause if it made the grant to the church. But Missouri was not violating the Free Exercise Clause or the Equal Protection Clause by deciding not to make the grant to the church. All right? So they could do it constitutionally, but they don't have to, is what the Eighth Circuit said. There's no part of the Constitution that requires them to make this grant, even though it might not violate the Constitution if they chose to do it. So the church says we're being discriminated against because we're a church. The church says the Free Exercise Clause of the Constitution requires the state of Missouri and other governments to be neutral toward religion. They can't discriminate against us because we're a religious organization. They have to treat us the same as other organizations when it's a general social welfare type program and is a neutral program. The state says no, there is no free exercise problem here. The Free Exercise Clause of the First Amendment protects your right to practice your religion, to have a church that worships your faith. We, Missouri, have done absolutely nothing to interfere with that. You can worship your faith all you want, you can have your church all you want, but nothing requires us to subsidize your playground. That's the tension on the two sides. There's a very important Supreme Court precedent here, although both sides disagree about the meaning of that precedent. In 2004, the Supreme Court ruled that the state of Washington, which had a general kind of public merit scholarship program for higher education for students in the state of Washington, the state of Washington could give out these merit scholarships to eligible students, but exclude from the eligibility a student who was going to basically go to an undergraduate divinity program in which he was actually going to study to be a minister. Not studying religion as history or religion as philosophy, but actually was going to study to become a minister. Supreme Court upheld Washington's exclusion of that student, that the state didn't have to include that student and wasn't violating any part of the Constitution by excluding that student. That was a 7-2 decision. Justice Scalia and Thomas dissented. It is safe to say this case was granted cert in January when Justice Scalia was still alive. So while we never are told who voted to grant cert, at the very least, certainly I think the conservatives on the court disagreed with the Eighth Circuit and would think that the church should be entitled to funding in a neutral way. Interestingly, there are many, many, many amicus briefs filed in this case. There are 20 states that disagree with Missouri. There are 20 states that have filed on the side of the church. There are civil rights organizations on both sides. There are religious organizations on both sides. I think the stakes are fairly significant. There are lots of neutral state and federal aid programs, and what the obligations are to treat church organizations neutrally and when you can fairly decide to exclude them, I think is an issue of great significance and great importance. The one last thing I'll say is, and this is purely reading tea leaves, and as to some of the cases earlier as well, this case is fully briefed and ready for argument and was in August ready to go. But the Supreme Court hasn't scheduled argument in this case yet, even though it's already issued its October and November argument schedules, which means one might surmise that the justices have some concern about this possibly ending in a 4-4 tie. There's no way to know that for sure, but that's at least one possibility for why it hasn't been scheduled for argument yet. If we see that it's not on the December argument calendar, then that almost certainly confirms that they're trying to put it off as long as they can, in hopes that they'll have another member of the court.
Thank you, Steve. Any thoughts or comments for Steve?
I'd just be interested in your reaction of how you think the court, to the extent you've developed views on how you think the court would come out. I've done 2 other Supreme Court preview panels, and it's funny, on one of them I had someone who, I won't say who it was, but someone who'd safely describe as left of center. Oh, this is an easy case, right? This is like Locke v. Davey, playing the joints, the state wins. And I was on another Supreme Court preview panel that had someone who's, you safely say, right of center. Easy case, right? How could they exclude a church from this general public benefit program? So I think so I'm just wondering if, from an academic vantage point, if you have a more...
I agree strongly with both of them. No, just kidding. I don't know. There's some merit to the argument that this is different than the Washington State case, the idea that a state can exclude somebody who is actually going to study to be a minister could be a different argument than saying a church wants to be able to participate in a general public welfare program in which they're subsidizing playgrounds. So I don't think this is an easy case, but I think it's probably an agenda case, if you will, for the conservatives. And where there's a swing vote or not, I'm not sure. It's not even entirely clear where Justice Breyer is on this, because in the 2004 case, he joined the concurring opinion that Justice O'Connor wrote. So I think the votes are kind of up for grabs here.
I'll go out on a limb and say 6-2.
But which way?
Which way?
I think that the only people who are likely to side with the state are maybe Sotomayor and Ginsburg, and that the church could easily, the church could win this case with more than just the conservatives.
Okay, so
Just a guess.
I'm sorry. What we're going to do now is move to Chapter 6, if you're keeping score at home, which is a look at the court's future. But we begin with a look back. Quick comments on the Scalia legacy. Is there a lasting legacy beyond any individual decisions, just the way he conducted himself on the court, and has that changed anything?
Oh, I don't think anyone could reasonably doubt his lasting legacy. I think Justice Kagan may have said it best. This was before Justice Scalia passed away in December. She was giving a lecture at Harvard Law School, and she began her lecture by saying, "We are all textualists now." And I mean, that's a pretty bold statement from a Supreme Court justice, given how fraught the discussions about originalism, textualism, other things.
Explain what that means to people.
Yeah, sure. So we are all textualists now, meaning, I think what Justice Kagan meant when she said that is there's been a fundamental change in how both judges and advocates and students, how they're taught about how you go about deciding cases. And I think what she was referring to there is particularly in statutory interpretation. although it applies, I think, to some extent in a different way in the constitutional context. But look, if you go back and look at opinions, Supreme Court opinions, written, 40 years ago, or before that, in the 70s, 60s, 70s, and whatnot, you could read a Supreme Court opinion, and you might not get to the text of the statute until the end or in a footnote or something like that. They're talking about the legislative purpose, the history, the context, all of those things. Same with looking at briefs written from that time. You look at old Supreme Court briefs, including from the SG's office, where I used to work, not at all kind of focused necessarily on the text of the statutes. And, there are various areas, implied rights of actions, all sorts of different areas where you see that. That is no longer the case. And while Justice Scalia might not be solely responsible for that, I think you would have to say that perhaps his voice, more than any other, has at least changed the discussion about how you go about thinking and writing and talking about these sorts of cases. In cases now, statutory interpretation cases, without fail, regardless of the level of ambiguity, regardless of how you parse it, you start with the text of the statute. Everyone agrees on that. That's where the battleground is, and then you use all these other tools in the bucket of statutory interpretation to reaffirm your view of the text. And I think that's with us for the long haul. And I think that's really one of his lasting legacies.
Any other thoughts on Antonin Scalia?
Yeah, I think he's also fundamentally changed the way we talk about and think about the Constitution. I think, he was a big proponent of originalism, and there's lots of, debate around the margins about what exactly that means, but the basic idea is you need to pay attention to, what the Constitution meant at the time it was enacted. What does the Constitution's text say? What does the Constitution's history say? And I think it's a real credit to Scalia that he changed the conversation around the Constitution. Just like Justice Kagan has said, we're all textualists now. Progressives now, including my organization, really embrace the Constitution's text and history. Justice Ginsburg has described herself as an originalist. Even her opinion in Evanwell that Rich was talking about earlier, she said we must begin with constitutional history. I think Justice Scalia was often wrong about where the Constitution's text and history leads. I think if you look at the whole document, including, for example, the Reconstruction Amendments, like the 14th Amendment we were talking about earlier, it's a fundamentally progressive document. And so, he was wrong in thinking that it didn't allow for affirmative action, that it didn't allow for a woman's right to choose. I think he was wrong about where it led in many instances, but he still deserves a lot of credit for focusing us on the Constitution. So we ask that question, what does it mean?
I also think he's at the center of a conservative legal movement. Before Ronald Reagan became president, the conservative legal movement in this country could have met in a phone booth. It would have been Robert Bork talking to himself. And when Scalia died, the Federalist Society was pushing out the walls of ballrooms, bulging in size and numbers. And I think Scalia plays a very central role.
Was he the leader of that movement?
Not the founder of it, but
Right.
but
No, but I mean, as far as impact and
patron saint of it. I think.
then who is there an heir?
I don't know.
No.
Two other things I'd say very
Paul
briefly.
Clement.
Two other pieces of his legacy, obviously, are oral arguments and writing, and both areas where he excelled, depending on your point of view, maybe. Oral arguments will never be the same, although they have changed, obviously, without him to some degree, but the fact that it's a hot bench, when you ask about did he start it, yeah, I pretty much he started the hot bench, I think it could be argued, and it's only gotten more and more hot as each justice, other than Justice Thomas, has come on. And then just his writing is acknowledged to be by most on all sides wonderful, sometimes a bit too acerbic, but wonderful writer. And there have been a few of those on the Supreme Court, but not that many. And I think there are many, particularly Justice Kagan, who aspires, and will say so, aspires to his level of sort of strunk and white, precise writing. Wasn't always quite as nasty, perhaps, as some of his dissents have been, or might be interpreted by some to have been in recent years, but just beautiful writing. And so I think both in terms of the way oral arguments go and the way briefs and particularly dissents, not briefs, opinions and dissents are written, he clearly has a legacy there.
What I'm going to do now is maybe my version of some court consolidation of cases is, in the interest of time, we're getting tight, and I want to see if you have questions or comments. Speaking of the future of the court, I was going to spend some time on Merrick Garland's fate, and also spend some what-if time on what if Hillary Clinton, what if Donald Trump. Let's roll those into one and give each of you a minute to just give us some insight on what do you expect, what are some of the more likely outcomes for the future of this court, whether it involves the fate of Merrick Garland or what a court might look like under a Clinton presidency or a Trump presidency. Let's reverse the order and start with Steve this time.
Thanks. Today has been 196 days since Merrick Garland was nominated. It's clear that Merrick Garland is not going to be confirmed, certainly before the election. I'm in the skeptical camp about whether he will be confirmed in a lame duck session, which seems to be a popular theory. There's so much crow that Mitch McConnell would have to eat that I'm not sure it's humanly possible, having said 1,000 times that the next president should fill the vacancy.
So it would take contradiction and potentially hypocrisy, things we never see in this town.
Right, never happened.
Never.
So if I were betting, I would bet that Hillary Clinton will make a Supreme Court nomination, or Donald Trump on January 21st or 22nd, and that person will not be confirmed in time to sit in oral arguments in the coming Supreme Court term. We will go all the way through the end of arguments in April with 8 justices.
Richard.
Yeah, I think that the one thing that I can't get past is the possibility that on November 9th, or whatever that Wednesday is, the possibility that Hillary Clinton, if it's Donald Trump, it's not going to be Merrick Garland, so we know where we're headed there, and he's got an ever-growing list of 21 justices that he would nominate. Doesn't include his sister yet, but we could get to that. If it's Clinton, however, all the talk about so much that she has to do, forming a cabinet, everything else, so likely that she gets some more Supreme Court nominations, even if she only serves 4 years, the great likelihood that she would see a Ginsburg or a Breyer retirement during that time, that it just seems logical that Merrick Garland would still be the odds-on favorite, and if she wanted to get that out of the way sooner rather than later, she could make some sort of grand pronouncement on November 9th that says, I think the Senate ought to allow President Obama's nomination. It's not mine, it's his, and as she's said all along, but that the Senate might be more inclined and Mitch McConnell might get rolled by his own Republican conference to try to do a lame duck confirmation of Garland. It serves a lot of purposes, right? It settles something for Hillary. She can go on with her administration without feeling the pressure from interest groups that would surely want somebody, not so much somebody more liberal than Garland, because I think he lines up with the liberals on the court in most cases, but somebody younger. That's really the major concession that Obama made, nominating a person who's 63 years old, who isn't going to serve 40 years. So I think that is a distinct possibility. It comes up against time. When would Congress come back? They've got a CR now, I think, that goes into early December. They've got to come back and do something on the budget, et cetera, anyway. But would they have time to have Judiciary Committee hearings and a vote? I think, yes, they probably could if they squeezed it in, and that's a possibility.
Brianna.
Yeah, so I think I want to pick up on something that Rich just touched on briefly, which is that, regardless of, whether and when Judge Garland gets confirmed, and all I'll say about that is that it's stunning. I think that we are where we are, that it's been nearly 200 days since he was nominated without a hearing and a vote. But regardless of what happens with that vacancy, we have 3 justices sitting who are 78 or older. So the odds are the next president will have, 1 or more additional vacancies to fill. It's at least certainly possible. And so I think we're at a real transition point for the Supreme Court where, what happens in this election could have a huge impact on the future trajectory of the Supreme Court, and also it's worth noting the future trajectory of the lower courts as well, which get a lot less attention, but are hugely important because that's where all of the cases that we talk about that are before the Supreme Court start. And I think over the course of the past decade, while we've been under the Roberts Court, we've seen the law moving to the right in a number of areas. And so depending upon what happens in the election, depending upon what happens with the composition of the court, we could see real changes in a number of areas. And one that I'll highlight that I think it's really worth watching is class actions and arbitration. I think we've seen a real effort in this court to limit individuals' ability to access the courts, to vindicate rights that they have under federal law, channeling them into arbitration, making it more difficult to sue in court. And so that's an area where, depending upon what happens with this vacancy and any other future vacancies, we could see a real shift.
Pratik.
Everyone's made good points here. I think it's so unpredictable. I don't really have much of a prediction to add here. I think the nature of who wins the election and the justice that they appoint is obviously going to make profound changes in certain areas of the law, and it's hard to predict until you know who it is and how it's been. And there have been surprises in the past, so just put a word of caution as to making predictions. Yeah.
Good one, good one. Okay, we have time for a couple questions, and we have a couple people who magically appeared through trapdoors with microphones to help you ask those questions. Does anyone have a question for us? Yes, sir.
Hi, I just wanted to thank you all for your contributions. I really appreciated it. I was wondering, you said you don't know who's going to take up the conservative mantle nationally. Who do you see as taking up that mantle on the court?
Already it's, I'll speak first, but probably with less knowledge than my compatriots here. Already it seemed to be Justice Alito and sort of his sometimes silent partner, Justice Thomas. I mean, they've formed much more of a partnership, it seems, on the court in the last few months in terms of dissents more than anything else. And I think that it's some combination there of the two. Not to be fooled, no one should be fooled by Thomas's silence during oral arguments. He's a force on the court. He's been a force of one or sometimes two with Scalia. Then Alito came on the court in 2006, grew to three. I think those are the two. Roberts is a whole different question. Constitutional Accountability Center just did last year a wonderful package on the Roberts Court at 10. Roberts heading into the future is a whole other question, probably worth a whole other panel, because where he goes, if the court goes liberal, in terms of his assigning power and the like, how he evolves on a potentially liberal court is going to be fascinating to watch. But I think Alito and Thomas is sort of the answer there.
I mean, I would just note that Thomas last term, counting majorities, dissents, and concurrences, wrote more opinions than any other two justices combined.
Okay, we can squeeze in another question or two if anyone has one. I see a pass. Okay. Oh no, you got someone right here, gentleman in the blue tie.
Just a brief question. I noticed that two of our panelists are former Supreme Court clerks, and I'm wondering if there's any insight into the inner workings of the court and how the obvious reduction of clerks in the last year with Scalia's passing has affected review of cert petitions.
I thought you were going to look for career advice, a reference.
Well, I might have a follow-up.
Well, I mean, I think we don't really know as to the clerk question. I mean, last term, the Justice Scalia's clerks, I believe, went to two of the other justices, so I imagine they were still contributing to the cert pool. I assume this year there is going to be a reduced number of clerks. I think, given the huge number of cert petitions that there are every year, it'll mean a little bit more work for everyone, but I don't think it will, meaningfully change things. I think, the real question we're seeing in the cert process is the one we talked about, which is whether the justices themselves want to shy away for the time being from cases that are likely to divide them 4-4.
Yeah, I agree with that. And just for folks who may not be as familiar with the cert pool, so how cert petitions work is, unlike every other aspect of a clerk's job where you're just working individually for your justice, the justices, all but one justice historically, has participated in what they call the cert pool. That is, one clerk writes a shared memo for 8 of the 9 justices or 7 of the 8 justices, as it may be. And they use that as kind of the starting point for their analysis of a particular cert petition that they then discuss at conference. One justice historically, back when I clerked, it was Justice Stevens, who would sit out of the pool to make sure that there would be a second pair of eyes on each petition. Now I believe it's Justice Alito sits outside of the pool to make sure that there's a second set of eyes. Now what it means for the clerks for Justice Stevens back when I clerked and for Justice Alito now is they're viewing all 8,000 or so petitions, not writing formal memos like the rest of the clerks in the cert pool do. So that's how that works.
I want to thank those of you joining us via the webcast. Thanks for visiting wilsoncenter.org. For those of you in the room, thank you as well. I want to also thank Kathy Hawk, the editor of this fine publication, and Mabel McKinney Browning, the great Mabel McKinney Browning, who I referenced earlier. And most of all, I want to ask all of you to thank me in joining this brilliant panel, this great minds, legal minds, sharing their time and expertise with us. Thank you. And we'll go World Series predictions when we go off the air, since we can't make court predictions. Thank you very much.